So when I say contemporary gender issues, I don't mean contemporary to right now. Um, to some extent I do, and I definitely will extrapolate and talk about that. But in terms of contemporary gender issues, we're really talking about the battles of the 1960s, 70s, 80s, 90s until today. So we're really talking about a 50, 60-year period in which we see a lot of these gender-based distinctions being torn down. As I sort of alluded to in the question and answer period, which if you weren't in the class you didn't hear, the women's rights movement begins to piggyback the black civil rights movement of the 1960s. Largely because, and frankly, the black civil rights movement was seeing success. And so the women's civil rights movement began to adopt very similar plans and very similar strategies in terms of accomplishing what it was that they wanted during this period. And all of this takes place following the switch of the court in the 1930s. It's decided to turn away from economic-based issues and turn more towards, as the court says, discrete and insular minorities, as the court tells us in footnote 4 of Caroline Products. And so it seems that, at least in part, that the U.S. during this time period should be primed and should be more open to questions about gender-based distinctions and questions of gender discrimination. But what the court and what society largely it begins to use, and I do mean this use, as a tool against women, is the fact that they are not, nor had ever been in the United States, a numerical minority. And that perhaps maybe they were only a political or economic minority. One of the many arguments that were used against the women's movement in the United States in the 1930s, 40s, and 50s was, hey, women have the right to vote now. If you disagree with all this stuff that exists, all of you should vote collectively in the same way and you'll be able to change it. So not only the fact that there was a history of discrimination, but this newfound ability to vote was used as almost a weapon against women, saying, hey, we live in a democracy. If you want stuff to change, all of you turn out, vote, and it'll change. That's how democracies work. Without recognizing that the vestiges of coverture and the institutions of gender-based discrimination were erected so strongly that even if women would vote collectively the same way, they still would not be able to tear down all of these institutions in one fell swoop. But this idea of numeric minority was used as a targeted weapon with purpose. The court does begin to deviate from the type of decisions in Bradwell, but the process is exceedingly slow. This movement begins to start for the court largely in the 1930s and 40s, but we don't see a full-fledged statement that gender-based discrimination exists and we have to do something about it until the 1970s. And the only reason we see it in the 1970s is because of work by people like Ruth Bader Ginsburg. So very much like Maya Bradwell and Belva Lockwood in the 1870s, it's really the work of people like Ruth Bader Ginsburg in the 1960s and 70s that we see the next big change in terms of gender discrimination in the United States. And these take place nearly 100 years apart. So I can't tell you how exceedingly slow this process was. What was started by Belva Lockwood and Maya Bradwell legally in the 1870s is the same sort of questions that are getting asked 100 years later in the 1970s by individuals like Ruth Bader Ginsburg. And so to say that the court moved exceedingly slowly away from Bradwell-type decisions really sort of downplays the amount of, whatever the inverse of alacrity is, in terms of how the court transitions. And we'll see this play out on Tuesday, when we do the first few cases from this section, as we see the United States Supreme Court limp into modernity, and rarely begin chipping away at some institutions of gender-based discrimination without ever tackling the big question in the room.